Okay.
I think you should thank the audience for still being with us.
I know it is very demanding to be here. It is a second day and not the last one. And with so many important presentations and so many wonderful speakers, and also the final panel of the last day, already you got to know each other, so therefore you have a lot to discuss among yourselves. But please turn your attention to this last panel before we finish for today. My name is Arkadiusz Radwan, and I will have pleasure and honor to chair this panel. Can we change slides, please? Can we have slides for this panel? Very good. So this panel is probably going to be slightly different from most of the panels we had earlier today and also yesterday. This is a very interdisciplinary conference, but still, as we see, historians, political scientists probably dominate the discussion, and those are the perspectives that they share with us. This panel has its focus on more legal part. We are not all lawyers. This panel is also multidisciplinary. It's probably the most diverse. We have people of many backgrounds, genders, nationalities, academic ranks when it comes to seniority, and also, technically speaking, we will have almost half of the speakers connecting remotely, with other speakers being on site here with me. We will not be able to address all the legal issues. There are conferences that go for 2 days or longer addressing only legal part. So we will need to be selective and also keep account of the audience. It is not a very technical legal conference, but still I think the questions of criminal liability hit up imagination and emotions of many, many people. The title of this conference, Politics of Memory as Weapon, and we hear of weapons every day. We hear of Russian weapons killing innocent people, targeting schools, hospitals, civilian sites, but we also hear discussion of delivering weapons to Ukraine by countries who disagree with the worldview whereby the stronger takes it all and the weaker must surrender, by the countries who believe that rule of law and not just rule of force should govern the international legal order. And again, the title of the conference is now about politics of memory as a weapon. And as we can easily do this dichotomy when we think of weapons proper, some to kill and some other to preserve lives, the question that will come up here is whether this moral dichotomy can be also made for politics of history and memory as a weapon. How can we make sure that it is used for a good cause and not for the bad one? And this will be this part of the panel that is around legal tools, legislation and case law as a part, or also setting up institutions as a part of policy to somehow create narratives by different countries, and specifically we'll be looking at how Russia has been doing so and how Ukraine has been doing so. And another subset of questions here is even more strictly legal. We will start in a minute by a talk, probably very interesting to everybody, the chances and the prospects of putting the ones who are responsible for war crimes and the question of crime of aggression as the mother of all crimes in front of, to bring them to justice, what form of justice, the prospects of setting up a special tribunal. But we will also be discussing questions of transnational justice. We want to look forward, how things might unfold in the future, how these atrocities can be dealt with as the time passes. And also, maybe even more legal take will be on the just finished story of Russia and the European Council, how this farewell process unfold in steps. Hopefully the techniques will work with us and we will be able to smoothly go through this panel. I will do my best for the benefit of the audience that is present here in this on-site and also connecting with us online. Having said this, please let me introduce our first speaker, Aarif Abraham. We changed a little bit the order that you see on your schedule because of time restraints. Aarif needs to catch his flight back, although it is tempting to make you be late to have you tomorrow also. But your topic will be, as I mentioned, about this very hot issue of responsibility for the crime of aggression. Before I give you the floor, Aarif, please let me say a few biographical data. Your bio is very impressive, and I will be just short with introducing you. Aarif is a lawyer with an impressive track record of practicing law, both internationally and domestically, spanning criminal law, international law, and also previously civil law matters, and as we discussed, also taxation before. He's now one of the leading lawyers in international human rights and international arbitration. He's recognized by Chambers and Partners 2021 as leading barrister in international law. His background is also quite interesting. He studied economics and philosophy at the University of Oxford and then got his master's degree from University of Bologna, degree in human rights. He is now practicing barrister, engaged in human rights and international law. He advised many clients, private and public, among them many high-profile public bodies in the UK and outside. He is now especially involved in handling the question of criminal responsibility for crimes committed in Ukraine. He works with Professor Philip Sands, who was, I think, the first one to call for establishment of the special tribunal. But he has been involved in other projects, Ugar Tribunal, the Yazidi Justice Committee, and he is now also at the roster of candidates as an expert for several United Nations bodies for justice rapid response. Having said this, I would like to give you the floor to tell us more about the prospects and idea for setting up this special tribunal for the crimes of aggression and crimes committed in Ukraine. Thank you.
Thank you very much for the very, very generous introduction. And may I also begin by thanking the organizers for the invitation to speak today. It's a real honor to be here, and particular thanks is owed to Bartosz and Arkadiusz for being my contact points for this panel. What I seek to do today is to use my 20 minutes really to make 4 points. I have got a set of slides, but to be honest, I don't use slides very often in my advocacy, so I tend to ignore them, but I'll try and flick through them as I'm talking. The 4 points really that I want to convey today are as follows. Firstly, to explain how the acts and the crime of aggression fit into the pattern of international crimes currently being committed in the ongoing armed conflict in Ukraine and the current legal accountability landscape. Second, outline what the definition of the crime of aggression is and how it is distinguished from acts of aggression, and why accountability for this crime can only be ensured by the creation of a special tribunal. Third, I will briefly discuss the history and the precedents behind the crime of aggression. And fourth and finally, I will explain the practicalities of the creation of a special tribunal. And importantly, I think for a group like this, I will also address the 4 major criticisms or critique in the creation of a special tribunal, which relate to possible competition with the International Criminal Court, the issue of immunities of state officials in Russia or Belarus. Third, the issue of selectivity, the idea that this is a form of selective justice. And finally, the idea that setting up a tribunal might set dangerous precedents for the future. And finally, I'll conclude by outlining why a special tribunal is important, not just for the conflict in Ukraine, but really ought to be a critical concern for all countries. I'll begin with my first point. I should probably shift the slides. I'll begin my first point. As we all know, on the 24th of February of 2022, Russia, aided by Belarus, began what is now widely acknowledged to be the largest cross-border land war in Europe since the Second World War. That's notwithstanding the recent and devastating armed conflicts in the former Yugoslavia in '92, the ongoing conflict between Armenia and Azerbaijan, and of course the 2008 conflict in Georgia by, again, another instance of Russian possible aggression. The latest invasion of Ukraine followed, as we know, from the illegal occupation of Crimea by Russia in 2014 and the de facto illegal annexation of parts of the Donbass beginning in 2014 and extending into 2015. These acts uncontroversially stand as a blatant challenge to the global prohibition on the use of force under territorial conquest, as well as the prohibition of acts of aggression. Now, during this ongoing armed conflict, there has been a very widespread commission of crimes by individuals affiliated to Russian state agents, organs, or officials, including its armed forces, and could constitute war crimes, crimes against humanity, and presents the possible risk of genocide. Russia says that these crimes are not occurring, despite widespread and credible allegations and widely available evidence. Alternatively, Russia says that they are not state-sanctioned and/or that their actions in Ukraine are motivated by humanitarian considerations, the idea that they are protecting Russian-speaking Ukrainians from what they say is genocide or other crimes. That is another claim that remains largely unsubstantiated. The statistics in this conflict to date are shocking and are really worth repeating today. The numbers may have changed a little bit in recent weeks, but currently it is estimated that the Ukrainian civilian casualties alone number approximately 20,000 lives and growing. Some 16.5 million people have been displaced, and of those, over half have become refugees, and predominantly women and children. Ukraine may have lost 15,000 armed personnel, and Russia anywhere upwards of 50,000 troops, although the official Russian estimates are 5,000, and we do not simply have reliable figures on that. Ukraine's economy has shrunk by a half, and some 20% of its land was until recently, or is still, occupied, and in fact it was more than that just a few weeks ago. You'll see the relatively current state of play. I think that was a few months ago, and the lines haven't changed a great deal, and that roughly constitutes 20% of the landmass. And in respect of crimes, Ukrainian domestic prosecutors alone are considering, as of last week, some 66,000 international crimes allegedly committed by Russian forces. So who has the authority to investigate these crimes and hold to account those who are responsible? Now, responsibility under international law is divided in two ways. The first is the idea of state responsibility, and second is the idea of individual criminal responsibility. Over war crimes, crimes against humanity, and allegations of genocide, the International Criminal Court has had jurisdiction ever since Ukraine self-referred the situation on its territory to the International Criminal Court in 2014. Now, what this means is that all such international crimes committed since 2014 on Ukrainian territory, where it concerns high to mid-level perpetrators, can be prosecuted before the International Criminal Court, where Ukraine is unable or unwilling to do so. Now, that includes any perpetrator of any nationality, and of course that includes Russians or Ukrainians. Of course, Ukraine itself has mobilized a vast investigation and prosecution exercise through its domestic court system to prosecute war crimes, and it's only where Ukraine is unable or unwilling to do so is where the International Criminal Court is seized of jurisdiction. In respect of allegations of state-sponsored genocide, whether by Russian forces in Ukraine or Ukrainians committing such a crime against their own Russian-speaking nationals, the International Court of Justice has jurisdiction to consider any such allegations and adjudicate upon them. The obligations of prevention, prohibition, and punishment of genocide are all engaged, and this is a question of state responsibility or the failure of states to uphold their obligations under the Genocide Convention. So the question is today is that what crimes are not within the scope of any formal international court, tribunal, or mechanism. And that principally is the crime of aggression, which brings me to my second point. Russia's use of force against a sovereign Ukrainian state constitutes one or more illegal acts of aggression contrary to binding international law, having not been authorized by the UN Security Council, of which of course Russia is a permanent member, and it not being an act of self-defense. As such, this is a violation of the prohibition on the use of force and also the prohibition on territorial conquest, as well as, and critically, the prohibition on committing acts of aggression incurring international responsibility of states. That is distinct from considering aggression as a crime. An aggression is considered as a crime incurring individual criminal responsibility of leaders, and as such, those exercising control over or directing the political or military action of these acts, in the words of the Nuremberg Tribunal, are committing the supreme international crime. Why is it the supreme international crime? But for the acts of aggression, but for the crime, you would of course have no war crimes, no crimes against humanity, and no risk of genocide. And again, these are distinct crimes from the crime of aggression. What do we mean precisely by the crime of aggression? So you can read the definition, hopefully I've put it up there. The crime of aggression means the planning, preparation, initiation, or execution by those exercising effective control over or directing the political or military action of a state of an act of aggression by its character, gravity, and scale, which constitutes a manifest violation of the Charter. What are the acts of aggression? So they have been delineated in the UN, in a UN General Assembly resolution in 1974. They've also been delineated in the Rome Statute of 1998, and they are also part of customary international law. I won't have time to go into them all, but in summary, acts of aggression include invasion or attack, military occupation, bombardment, blockade, the attack by the armed forces of one state on the armed forces of another state, the use of territory by one state to allow acts of aggression being committed in another, and the sending by or on behalf of a state armed bands, groups, irregulars, or mercenaries into another state to commit these various acts. So as aggression against Ukraine continues, critically, there is no international body before which those responsible in Russia or Belarus for this crime can be brought. This brings me to my third point. What are the origins of the crime of aggression? Now, lest we forget, the crime of aggression is not a principally Western construct. And in fact, the Soviet Union, thanks to the conceptual work of the Russian jurist Aaron Treinin, was actually the major player in insisting on its prosecution as a truly international crime in Nuremberg. In fact, just as by way of example, on the 1st of November 1943, as the war was raging, the Soviet Union, the United Kingdom, and the United States issued what was called the Moscow Declaration, and this declaration gave, and I quote, full warning to the Nazi leadership of the Allies' intent to pursue them to the uttermost ends of the earth in order that justice may be done. And indeed, in the first set of trials at Nuremberg, all 22 senior Nazi leaders were tried with conspiracy to commit aggression, 8 of those were convicted, and 16 of those 22 were charged with aggression, and 12 of those were convicted. So how was Nuremberg able to try the crime of aggression? Then it was known as the crimes against peace. And what sources might we look today as inspiration for creating a special tribunal for the crime of aggression? Well, states are able, through treaty, to provide legal and enforcement powers to new institutions, either through multilateral treaties or treaties with international organizations such as the UN, or with regional organizations such as the EU. Now, that is exactly what Allied states did by coming together to create the Nuremberg Tribunal. And when challenged during the Nuremberg trials as to whether they had the appropriate jurisdiction, this is what the judges said in the judgment. They have done together what any of them might have done singly, for it is not to be doubted that any nation has the right thus to set up special courts to administer law. This law is not static, but by continual adaptation follows the needs of a changing world. Indeed, in many cases, treaties do no more than express and define for more accurate reference the principles of law already existing. Now, as to the source of those laws, the Nuremberg judgment traced and documented the international and customary origin of the crime of aggression, and it reiterated that the consequences of aggressive war were not confined to the belligerent states alone, but affect the whole world. So as far back as 1946, the judges were articulating the idea that actually a majority of states in the world were proscribing illegal wars and aggressive wars, and that's where their jurisdiction stemmed. Now, in relation to treaty precedents for the creation of tribunals, I've identified on a cursory review approximately 25 relevant agreements since the 1929 Kellogg-Briand Pact, which is often cited as the key precedent for the prosecution of German and Japanese leaders for waging aggressive wars after the Second World War. Now, 10 of those are particularly relevant, but I'm conscious we're short of time, so I'll just briefly mention a handful. We, of course, have the 1945 Charter, an agreement on the International Military Tribunals. There was really nothing since then until the 1993-1994 statutes on Rwanda and Yugoslavia. In 1998, of course, we had the Rome Statute establishing the International Criminal Court. And then we've had various other courts that are really interesting precedents. In 2002, there was an agreement between the UN and Sierra Leone for a special court to try the Liberian leader, Charles Taylor. And in 2012, again, a very interesting agreement between the African Union and Senegal, which created the extraordinary African chambers within the Senegalese judicial system, which tried the then Chadian president, Hissène Habré, successfully. And there are various other precedents. Now, whilst the majority of these precedents dealt with a range of international crimes, only two really substantively addressed the crime of aggression: the Nuremberg trial, the Nuremberg tribunals, and then it was almost over 60 years when in 1998 the Rome Statute introduced the idea of the crime of aggression again in a modern conception of it. These precedents helpfully point to the possible means and methods of creating a special tribunal, which brings me to my fourth and final point. How would a special tribunal be created for what's happening in the Ukrainian conflict? Now, a special tribunal could be a strictly international tribunal set up upon recommendation by an international organization such as the UN General Assembly, or through a multilateral treaty by willing states, and this treaty, either with the UN General Assembly or with a group of states, would apply international law derived from custom in addition to Ukrainian law, which proscribes the crime of aggression. Incidentally, somewhat of an irony, the Russian and Belarusian statutes also proscribe the crime of aggression. An alternative way of creating a tribunal is to create what's called a hybridized chamber within the Ukrainian court system. So essentially, this is a Ukrainian court that is an extension of their current judicial system, applying international law and Ukrainian law, but situated outside of Ukraine. Alternatively, it would be what's called a freestanding hybrid tribunal, which is essentially an internationalized court with some Ukrainian domestic elements to it. Where would jurisdiction derive from? As I've said, the jurisdiction could derive from Ukrainian law, which proscribes a crime of aggression, together with customary international law, which proscribes the crime of aggression and has since 1946, if not before then. Now, the creation of this tribunal, for those that are not familiar with what's happened since February of last year, is no longer academic. The actual proposal stemmed from an article Professor Philippe Sands, QC, wrote days after the invasion in February to suggest that a Nuremberg-style tribunal should be created for what Russia is doing in Ukraine. And over the course of the past year, we have moved from that being a purely conceptual idea to one which is in the process of possibly being created very soon. So what we have seen is we have moved from Ukraine and Eastern European countries taking the lead on supporting such a tribunal to a tribunal now being publicly supported by the European Commission, the Council of Europe's Parliamentary Assembly, as well as parliamentary assemblies around the world, and major powers including UK, France, Germany, and Netherlands, all expressing public support, and many other countries are supporting this privately. So what are the key criticisms and apparent stumbling blocks in respect of creating a tribunal and prosecuting these leaders in Russia and Belarus? The first key criticism is that it would compromise the existing International Criminal Court. Firstly, I would answer that the International Criminal Court has, in fact, no jurisdiction for aggression and only has jurisdiction since 2014 to try high-level individuals for war crimes, possible crimes against humanity, and possible genocide. Second, Russia is not a state party to the International Criminal Court, and membership of that court, as well as ratification of what's known as the Anti-Aggression Amendment by both parties to a conflict, is the only consensual way that the International Criminal Court would have jurisdiction. And even if that was to happen now, it would not apply retrospectively. A non-consensual referral to the International Criminal Court by the UN Security Council would of course be vetoed by Russia and possibly China. Third, the International Court of Justice, which I mentioned, deals with state responsibility, also has no jurisdiction as regards the prohibition of the use of force. The court will therefore not be in a position to find that Russia has violated this international legal obligation by committing acts of aggression, and therefore is under an international legal duty to provide Ukraine with reparations for damages that have resulted from Russia's war of aggression. Simply put, there is no international body, therefore, before which individuals may be tried for what you might call the original sin, the crime of aggression, from which all the other harm and crimes in Ukraine has flowed. It is because of this vacuum that a special tribunal would help enforce binding international law and would be complementary to, rather than in competition with, the International Criminal Court or the International Court of Justice. The second issue, and I'm conscious of time, is the issue of immunities applying to Russian or Belarusian leaders if brought to trial. Essentially, I'll try to be brief, but it is important to understand what immunity precisely means. First, state officials are ordinarily immune from prosecution in the courts of foreign national states for acts done in an official capacity. That's for obvious reasons, because that can be abused and put at risk the diplomatic relations between states. There is a strong view, however, that there is an exception for functional immunity for international crimes, even in foreign national courts. So that's not a problem. Second, ordinarily, serving high officials enjoy personal immunity for prosecution for as long as they hold office. So as long as Vladimir Putin holds office, in theory, he has personal immunity before all courts. An exception has developed over time for personal immunities of serving high officials before international courts or tribunals for grave crimes such as war crimes, crimes against humanity, and genocide. This would also be the case for the crime of aggression, which is a violation of what's known as a peremptory norm of international law, even though there is some debate about it. As such, an international tribunal can overcome the immunity hurdles, and there are various precedents for that. The third criticism is the idea of creating a tribunal for Ukraine is somehow a selective form of justice or constitutes double standards by the West. Now, for some, a future tribunal would be selective justice in light of the failure to prosecute crimes of aggression committed elsewhere. It is important to note, however, that the call for a tribunal has come from Ukraine. Its consent and cooperation are being offered in full, which distinguishes it from other states in which serious international crimes have been committed with impunity, and we ought to respect Ukrainian agency. Ukraine has a right to self-defense, and in fact is able to use all lawful means in response to the attack from Russia. If it's able to strike militarily at all proportionate targets emanating from Russia, then of course the very least it is able to do is to create a special tribunal using the pen. Also, Russia's actions against Ukraine are arguably one of the first to meet the very high threshold built into the definition of the crime, which in the modern conception of it was only agreed by International Criminal Court member states in 2010, although it has older roots. So the answer to the selectivity critique, therefore, is not to deny justice for Ukraine, but to advocate for the future amendment of the International Criminal Court statute to remove the current jurisdictional restrictions that are unique to the crime. We can do both tracks at the same time. And the final critique is that there is some concern among states that the creation of an ad hoc tribunal would set a dangerous precedent of other states coming together to create tribunals to try other officials in other states. So, possibly the leaders in Britain or in America for some future conflict that is yet to occur. And they also worry that Putin may be backed into a corner and compromise a future peace. Well, first, it comes as no surprise to say that since 2010, the International Criminal Court has jurisdiction for aggression, but critically, that jurisdiction was curtailed by a number of major powers. In an ideal world, an international criminal court with strong jurisdiction over the crime of aggression, applying widely to every state in the world, would have prevented the current situation we are in. We do not live in an idealized world, but one in which we make practical decisions informed by our ideals. A domestic or highly domesticated tribunal is completely precluded and would not be desirable in any case for the reasons I've mentioned. The crime of aggression by its nature is international and requires an international response rooted in the general prohibition in international law. Such responses are very rare. A UN General Assembly condemnation by a majority or a supermajority is not an easy exercise in diplomacy, and neither is the extremely tough work of creating a legitimate tribunal in line with accepted international norms and principles governing human rights. If such a precedent is created, then surely that would be a good thing. But this special tribunal will not create a precedent as such for other states, although it will fill a gap in international law. It will give renewed impetus for support for the International Criminal Court to expand its jurisdiction, and it will serve as a symbolic lesson to other states contemplating aggressive wars, which are, as I have already said, in violation of customary international law as well as the Rome Statute. So to conclude, I would like to highlight why a special tribunal now for the situation of Ukraine is important. A lean, bifurcated and highly international model, separating out prosecution work from eventual in-person trials, if perpetrators are apprehended, could start the work of critical contemporaneous evidence gathering immediately and at low cost, given the singular focus of the tribunal on Ukraine and a very narrow clique of perpetrators for a single crime. It is the surest and quickest route to trying the Russian and Belarusian leaders for international crimes. As a practitioner, I can tell you that trying senior leaders for war crimes, crimes against humanity, or genocide is notoriously difficult because of the difficulty in linking crimes committed on the ground by troops to senior military or political figures who are often well aware of the risk of having crimes attributed to them. And it could take many years, if not decades, to prosecute those leaders for those crimes, although that track, I argue, should still be pursued. Creating a special tribunal could deter perpetrators from further aggression. It would, moreover, reinforce the idea, the fundamental idea, that the prohibition on the illegal use of force and the crime of aggression is important, as is international rule of law. In the Russian context, given its previous illegal invasions or interventions in Georgia, in Moldova, and Ukraine itself, that is critically important. And the international nature of the tribunal would reassure the international community of impartiality and overcome complicated issues relating to immunity of serving heads of states and government. And finally, a tribunal would signal the disregard in which aggressor states are held by the international community. States ought to put aside their short-term domestic interests and put at the forefront the rule of law and international justice. That's why many of the institutions that we have today, international or regional, were created in the aftermath of the Second World War. Support for the special tribunal will do just that and make war-making that much harder in the future, both in Europe and further afield. Thank you very much.
Thank you so much. Thank you so much for navigating us through these difficulties that we see from getting to the point, from the point where we are to the operational tribunal. But you made references to some precedents, and there are, I'm not saying many, but there are some from the past. But do you think they are really valid for our cause that we are discussing? Most of the precedents that you were referring to pertain to countries that were relatively small. The one that pertained to a strong country was the Third Reich, Nazi Germany, but there they were unquestionably defeated. Now, how realistic it is and how far can we really draw conclusions from those precedents for our case, where we have a big country where we are not to discuss all the possible prospects of the war, but we all see that it is far from obvious that it will any soon end with a total defeat, as it was the case with Nazi Germany. So therefore, how valid those precedents are for the case we're discussing?
It's a very good question, thank you. So I think I should caveat that, of course, we have a precedent in the form of the Nuremberg Tribunal. Now, the Nuremberg Tribunal is not the ideal of justice. Since then, as I've said, we've had huge development in international law and the development of various concepts of international criminal law. So we've moved from, we know essentially how to create best practice. So what the best practice is in the creation of tribunals. I would slightly challenge the premise on which you've asked the question, in the sense that if you look at the former Yugoslavia, that was a huge country, powerful country. It had the largest standing army in Europe at the time, and that tribunal was created through the UN Security Council, and it was created and the work began during that conflict, where many thought that none of those senior perpetrators would ever be brought to justice. Yet we had over 90 successful prosecutions of some of the most powerful figures who had launched that conflict. And we saw them successfully brought to justice in The Hague. So I think that is an example, and I think the examples are diverse enough to give us hope that it's possible to create an institution now, and that is the critical thing, that it's possible to create an institution which can impact both the way the conflict is conducted, what kind of crimes are being committed, can be influenced by the fact there is the prospect of possibly bringing these leaders to justice one day. And the creation now allows a contemporaneous evidence gathering in the hope that one day perpetrators could be apprehended and brought before the tribunal. Now, I'm not saying that that is not a challenge. How do you bring the foreign minister, the heads of state, the heads of government of these countries to a future tribunal without having trials in absentia? That is inevitably going to be a challenge, but of course we just don't know how the future politics of Russia or Belarus will pan out. And there is every prospect, as we know historically, that even decades later, leaders are often brought to justice. Karadzic, Mladic, Eichmann, often decades after the crimes that they were alleged to have committed can be brought before a tribunal. And if you don't have a tribunal, of course, there's nowhere you can send them. And I'd say that probably the final point there is, of course, what is the alternative? So if you didn't have a tribunal, you can't send them anywhere. If you did, for instance, have an international criminal court which was seized of jurisdiction, a powerful state can also challenge the International Criminal Court. We know that it's been subject to huge challenge and contestation by powerful states, despite the fact that it was created to prevent crimes which are binding, crimes which are prohibited under international law and which bind states. So I think, yes, there are political considerations, power considerations. There is the possibility that it can be challenged in various ways. But I think you have to take the really long view on these issues, and that we simply cannot predict how the politics will pan out.
We certainly do not have time to discuss all the alternatives. One of them that is sometimes mentioned, although the prospects of being this implemented is the universal jurisdictions of national courts, but again, this has maybe even more limitations. But another scenario other than defeat of an aggressor country could be the change in power when the current regime is overturned. But now the question could come up, what could be the trade-offs? Because there could be different sub-scenarios of this regime change, right? It could be a total opposition, or it could be like similarly minded imperialist. Do you see any threats of bargaining or selective justice in this scenario of regime change, where some of the former leaders, the most compromised ones, could be used to whitewash the relations of Russia with the external world?
It's possible. So, I mean, there's a difficulty here. As I set out earlier, there's the idea of state responsibility, which is a responsibility of the state for committing violations of public international law. So for that, for instance, there is the prohibition of the use of force, which, if it was possible to bring Russia to the International Court of Justice, that would open up the possibility of reparations for huge amounts of harm that are almost impossible to quantify in scale and scope. So that is a separate issue, and there's a movement to create, for instance, a compensation claims tribunal for Russia to kind of deal with all of that and its aftermath in the long run. So I think that is a separate track, but an important one. The creation of a tribunal and how it impacts internal dynamics is difficult to kind of assess and evaluate, because there's not that much historical precedent for it. But of course, we know from Nuremberg that during the Nuremberg trials that very senior leaders did cut bargains for themselves. So they offered to have a plea bargain so that they become essentially the state's witness. So they turn on their fellow leaders and say, look, he was the guy that did it, and then offer the evidence on the basis for that. So there's that possibility. It can definitely change. Creation of a tribunal could change the internal dynamics in the sense, let's say there is a viable opposition figure in Russia who seeks to, for instance, come to some sort of negotiations. They could, in theory, throw their fellow leaders under a bus to say, well, we'll send them to The Hague to face trial. In response, these are our conditions. So, of course, there is that aspect of that. There are some other precedents. So, for instance, if, for instance, there was ever a UN Security Council referral to take a leader to the ICC, the UN Security Council, under the Rome Statute, can withdraw its consent to prosecute particular leaders. And of course, that is a consideration in terms of bargaining of whether you prosecute somebody who may be willing to sue for peace in order to get a whole host of other people in the dock for crimes. So of course, these are very difficult political calculations which in a way impact the idea of a pure justice. But I'm afraid there isn't, in a way, this concept of a pure justice beyond the ideal, and often we have to think about the wider interests.
Thank you so much. Do we have questions from the audience to our speaker? Please. Yes.
Yeah, thank you so much for your excellent presentation. My question refers to the key we are supposed to use when accusing certain people for war crimes. I mean, we know about Putin, Shoigu, and the rest who we know or we suspect with almost 100% conviction that they have made this decision to attack Ukraine. But what about other high, top-rank officials like the Prime Minister, who theoretically has nothing to do with the war because he's marginalized as a person and as a political figure, but he contributes to the whole war machine by organizing the whole functioning of the state during wartime, and also cares for economic aspects of the war, providing economic resources for the army. So where is this thin line between direct responsibility of the leadership and those who maybe are complicit to a certain extent, but are not qualified for the tribunal? Thank you.
I can answer that relatively quickly. So the crime of aggression is distinct in the sense it is solely a leadership crime. So it only impacts political and military leaders who initiated, planned, prepared, executed acts of essentially acts of aggression and had effective control over those who were doing that. So we are talking about a narrow clique of perpetrators, but it's not as narrow as what we might say the troika, the president, the prime minister, the foreign minister, and head of government or state. So you can then go below that to generals, to senior military figures who will have been actively involved in preparing for this, planning it, executing it. So you probably get quite a sizable chunk of the senior leadership there, and as I said, far easier to prosecute them for this because it's almost accepted that acts of aggression were committed. The question is, do individuals incur criminal responsibility?
Very short, because we are running short of time. So if you have a very short question, please ask, and then all the other questions we will gather after all the presentations have been presented, right?
No, it's a very short question. Today, Kaja Kallas, who is the Prime Minister of Estonia, said she's against a hybrid tribunal, although Ursula von der Leyen last week said it could be a possibility to have a hybrid tribunal. What do you think about that? Why she's against a hybrid tribunal?
So there is a real issue with a hybrid tribunal in the sense that there are two possible risks. The one is the issue of immunities. So where a court is a hybrid, it could be either more domestic than international or more international than domestic. So unless it's an international court or tribunal and is considered as such, then serving high officials like the president or the foreign minister cannot be brought before it if it's considered more a domestic court or tribunal than an international one. So for various complicated political reasons, there's been a kind of charge to back a hybrid tribunal, partly because it makes the creation of a tribunal exceptional and a Ukrainian affair, so that there's less setting of a precedent for future conflicts in future circumstances. So that's why there's kind of been a jump on the hybrid idea. But there are some serious risks of that not being operationally workable, where one day you may have a challenge to its jurisdiction. So that's the reason why some states have said, look, we want a fully international tribunal that's impartial, independent, applying international law, because that will be the most successful and easy route to it. The question is, will powerful states want to back that with a risk of something similar being done in the future that might affect them?
And we hope you will still be able to stay with us to the end. Now we are moving forward with the next presentation, and our next speaker that I would like to present is Professor Kristin Bergtora Sandvik. She is a research professor in humanitarian studies at Peace Research Institute Oslo. Previously, she served as a director for the Norwegian Center for Humanitarian Studies. However, her main affiliation is the one with the University of Oslo, where she is professor at the Faculty of Law, where she teaches quite a broad number of subjects, sociology of law, legal technology, artificial intelligence, and robot regulations. She has also led a number of significant research projects in Norway and international, devoted to various aspects of security, ethical, humanitarian innovation, or data justice. Professor, the floor is yours.
Thank you. I noticed I wasn't the only one with my glasses. So, let's go. So, thank you so much for having me, and a particular thanks to the organizers for being very patient. So, my talk is a little bit of a continuation of the previous one. It's called Transitional Justice After Empire. And it is sort of a traveling show. So, I've been working as an activist and academic on refugee context and transitional issues since the Bosnian War, Rwanda, Uganda, Colombia, and now Norway after the terror attack. Last fall, I was called in to give a regular transitional justice talk in Georgia and in the country. And on my panel was a very respected Russian lawyer. This was a conference for Belarusian, Ukrainian, and Russian activists. And 5 minutes before we were going to start, he said, "I'm quitting the panel because I don't think this is possible. I don't believe in this transitional justice discourse for the situation we're facing." And this was quite upsetting, not for me personally, but just the fact that such a heroic figure would kind of give up. And the thing is, we can't really give up, right? Because there isn't really any other alternative. So I'll just walk you through some of my initial thinking on transitional justice and sort of what we as academics could contribute now. And given the beautiful last panel, I apologize for the illustrations, which are my own pictures, taken in Norway, Germany, and Georgia over the last year. So we are in sort of a post-empire context, right? So we're definitely past the British Empire, we're past kind of the European Empire in any shape or form. We are facing a rising Chinese Empire. But we're sort of in the middle here. There's a broad-based militarization in Europe going on now. It's quite a difficult conversation. I think our discussions yesterday and today illustrate some of the dilemmas we're facing. But I think we also should recognize something. The Ukrainian war has been an enormous gift to the European project. The spectacle of Ukrainian bravery, the unity, the strategies, has also unified Europe. And yesterday somebody said the Ukrainians have given up because of the bureaucracy and gone home. I would also say that Ukrainian women have kind of digitized Europe by very insistent complaining and insisting on rapid treatment. You see this in a lot of refugee bureaucracies across Europe now. Things are a lot faster and more efficient. So the impact of Ukrainian refugees in a lot of countries is going to be interesting to assess. I would like us to talk about transitional justice as an open-ended political agenda. Russia is there, it was there, and it's going to be there in the future. I realize that being a Norwegian, we share a border with Russia in the Arctic. We have a different view and different experience of Russia than many other nations. But nevertheless, the Russian people is not our enemy, right? We have to live together. We also have to find a way of moving forward beyond punishment. So I think my colleague here very eloquently articulated the possibilities and what it takes to get there. But we have to have a conversation that goes beyond punishment, that goes beyond the very limited possibility of law to produce justice and effect social change. So what kind of imaginaries do we need? What sort of idea of this common European order do we need to get to transitional justice, and what can academics do about it? And I think, you know, recognizing Ukraine as a European country means that we talk about Europe as a whole. This is taken in the Norwegian countryside. You see sort of random set of mailboxes, and then you see a stand for Ukraine sticker. I think this is very typical of a lot of rural countrysides across Europe over the last year. If we start with liberal, kind of the liberal 1990s American-based model of transitional justice, it's very infused with law, it's very infused with liberal democracy. It's premised in this idea that you need a definitive break with the past to move forward, and that this break is actually possible. There's also kind of a shared notion of a toolbox, which very often is quite lawyerly, it's legal, it's about tribunals, court cases, developing law, developing new concepts, and also a very short time frame. Nuremberg is sort of, you know, the grandparent on transitional justice right after the conflict. The tribunals for Rwanda and Yugoslavia right after the conflict. South African Truth and Reconciliation Committee right after the conflict commission. Colombia, even starting with transitional justice before the war is finishing. So the time frame is extremely short. And looking at this post-empire context we're in now, a short time frame is going to be very difficult. The other thing that I think we need to get beyond is this idea of balkanizing Eastern European kind of post-communist transitional justice. So there's a lot of scholarship on various case studies, a lot on illustrations, some on criminal cases, not a lot on truth commissions, some on restorations. And there's also a lot more skepticism in this scholarship than in kind of the more liberal Latin American, African studies scholarship on transitional justice. And very few comparative studies out of the region. So I think this is a very valuable body of knowledge, but I also think that recognizing Europe as a whole, not East, not as something else, but as Europe, means we need to move beyond this when we think about transitional justice. Then, of course, Ukrainian scholars have done a lot of work on this already, the last since 2014, but also before, kind of exploring projects, developing projects, and this is a very valuable starting point. But the type of transitional justice needed now is of a different order. So we have these three bodies, kind of transitional liberal one, the Eastern post-communist one, and the Ukrainian one. And my suggestion is that we try to sort of calibrate this into a larger European discussion. And then there are kind of some things that I'm concerned about. And you know, people have discussed Big Brother already today, so bringing up 1984 is not particularly original. I want to talk about memory holes, doublethink, and future time as some concepts we can be reflective on in the present. So a memory hole is any mechanism for the deliberate alteration or disappearance of documents, images, records. I think we've seen this today, looting of museums, changing of documents, manipulation of imageries and traditional cultural motives. A lot of this is going on. The Russian organization, broader in the region, Memorial, says, you know, however horrible the past might have been, forgetting it would make the future even worse. And I think this is why we're here today, right? We're here because forgetting this past, not documenting it, is setting us up for a very bleak future. And incidentally, I am noticing that, you know, we're not spring chickens in this room, right? There aren't that many 20-year-olds here, but it's their future, right? It's our kids, our grandkids. It's them we're trying for here. So how do we make these national pasts? I mean, we heard today of how Hungary, the Czech Republic, other countries, they all have different sort of local ideas of what happened and whose fault it is and what needs to be happen. We need to try to settle on a common past. At the same time, there are a lot of historians here, and you are not giving your ground. And I think we, as legal scholars, need to support you in insisting on this documentation. Although it's slow, it's tedious, it's very detailed, This is what we're building the future on. Then there's the resisting of doublethink. I'm including a slide that I found, or a poster I found outside my workspace. So I've worked on drones for a while. Drones in armed conflict used to be seen as something very sinister. Now it's become sort of a fundraising fun thing in the Norwegian public sphere, where private companies invest in drones, crowdsourcing for funding for drones. It's become a very public weapon in a very different way. So how do we think both about peace and about justice? This business of extremism is really haunting. So is this extremism, is this anything the Russian government doesn't like? Or is it now anything Russian? And I think, us in this room, we need to think carefully about this. So one of the younger activists in this Georgia seminar, she said she was labeled a foreign agent, and of course you have a lot of problems then with the Russian government. And she said, I didn't ask for this, but please do not keep your distance. And we see this with activists having problems getting asylum, getting protection, getting status in Europe. There are dissidents in their own country, but we're not protecting them because, after all, they're Russians. I think a lot of you might have heard about this unfortunate incident in Norway, in northern Norway, where they found a spy who claimed to be Brazilian, turned out not to speak Portuguese. I think only in Norway would you not double-check someone's resume, and at least, But there's a lot of, the hybrid warfare here, it makes everyone skeptical, right? So we need to try to insist on our principles. I think the law, there are a couple of slippery slopes. So obviously lots of slippery slopes in Russian judicial practice that we've seen over the last year. Constitutional Court pronouncing on the annexation, for example, but also in our own jurisdiction. So back in Norway, they're prosecuting Russian drone pilots, seemingly not with a clear basis in law, for example. These things are quite dangerous. The IOC is considering letting Russian athletes come back and compete. UN Special Rapporteur on Human Rights has said that it's discrimination not to. We need to have very clear but very dry legal discussions on these issues, otherwise we're ending up in a slippery slope. Then acknowledging the problems with timelines, and I think my colleague here said, this might take a very long time. And I think we have to get used to accept that. So in a seminal book, John Elster talked about immediate transitional justice, protracted transitional justice that would start like a decade after transition, and then postponed transitional justice. There is a speed legitimacy issue here. Transitional scholars have previously complained about the West asking Russia for too much. I know that the next speaker will talk about how Russia maybe wasn't prepared to enter the human rights legal system in Europe. But there's something about the speed here and who asks for what. The sheer number of crimes, how do we deal with these crimes without becoming too disappointed? What you see here is a newspaper ad from 1942 where the Norwegian Nazi government liquidates the property of all Jewish citizens in Norway. They cannot own anything. And of course, this was rapidly followed by rounding up everyone and trying to send them off to Auschwitz. It's absurd, right? It's a government sort of liquidating a group of people. It's taken us decades and decades and decades to get past this. Getting past Russian atrocities might take the same amount of decades, but we will need to invest in these decades. So where do we go? And this is where this shared future time becomes a challenge. So not only a shared past, but trying to move towards this shared future time. And it's difficult, right? So back to my Russian lawyer colleague at this panel. When we don't even know how we can start this conversation, how can we know when we will be successful? And this is where I think we as scholars can supply certain concepts, certain ideas about the future, about framing, and about the justice project we engaged in. But it does necessitate a new vocabulary, for example, that goes beyond election cycles or funding streams or statutes of limitations. And it's going to be very difficult. But I have to say another thing, though. Not in our lifetime. Doesn't mean that there's no timeline. And it also doesn't mean that there's a timeline without hope. But it just might take much longer than any of us have. Thank you.
Thank you so much. We will be now having an online presentation, but we want to use this little time we have left maybe to accept one question from the audience, and then we will be able technically to connect remotely with our next speaker. Yeah, please.
Hi. So I have a question regarding the speeding up of the legal process. In relation to, for example, the governments that are openly known to have accepted donations from the Russian oligarchs, like, for example, the Tory government and Boris Johnson, who has been obviously manipulated and didn't know, of course, what was happening. That's obviously said with irony. And how can these governments, who obviously were involved in financial benefit from the Russian oligarchs, who now some of them are by sanctions and some of them are not, how can the process of the legal prosecution be speeded up when obviously it's not in the interest of governments like that? And maybe it's a question to both of you.
Well, the idea was to have a quick question to the speaker. But my understanding is this is the question to two speakers at least. It's more to former speaker. This is also my understanding. Yeah, because the idea is, because we are encountering some difficulties, first running out of time, second having to reschedule the sequence of our speakers due to some limitations that stem from the former problem. So we will collect the questions and hopefully we will have still some round of questions towards the end, after everybody had a chance to present. And then we have a speaker who's already waiting, connecting from Cologne, I guess, right? Dr. Paula Rhein-Fischer, are you with us? Please let me quickly introduce our next speaker, and then I will give you the floor. So Paula Rhein-Fischer is a research assistant at the Institute for International Peace and Security Law at the University of Cologne. Her doctoral thesis was on factual mistakes relating to the exceptions to the non-use of force under the UN Charter Law. During her research time on the project, she spent some time working at the Columbia Law School in New York. Also during her legal traineeship referendariat, she worked, among others, for the European Commission for the rule of law and justice policy, and also for the Ministry of Environment, Agriculture, Conservation and Consumer Protection of the North Rhine-Westphalia Bundesland. And also in one of the leading law firms, international, known with offices in Germany. Now, she is now working on the Memocracy project. Sounds quite interesting. That is an international project. The full title is The Challenge of Populist Memory Politics for Europe Towards Effective Responses to Militant Legislation on the Past. And this is a project bringing together Astor Institute in The Hague, the University of Copenhagen, Polish Academy of Sciences in Warsaw, and the University of Cologne. Paula is also a reporter for the Oxford Reports on International Law in Domestic Courts. And I think with this background, she's a perfect speaker to address also a very topical question of Russia and the European Court of Human Rights, a farewell in stages. Paula, the floor is yours, please.
Yes, thank you very much. I hope you can hear me and that works, the technology. I will just quickly try to share my screen so that you can see my presentation. Okay. I hope this works. Yes, I think so. So it works, no? Yes.
Now it's better, yes.
At least I hope. Well, in any case, first of all, thank you so much for inviting me. It's a great honor to speak to you today, and I apologize 1,000 times for not being with you in Berlin. It was actually planned that I was there, everything was booked, and then I was tested positive COVID, and I thought I was be with you, but to stay in my living room in Cologne. So as you said, my research basically is actually on memory laws. However, today I will talk to you about a different topic, which is the topic of Russia and the European Court of Human Rights, a farewell and stages. As you all know, Russia has left the Council of Europe and with it also the European Convention of Human Rights after years of struggle between the two different sides. And on the other side, the Western European states, especially, who had the Russia, I mean. And I'm now asking in this presentation, how did we actually got here? And this is maybe also a prolongation of the two topics that we've heard already in this panel today, because European Court of Human Rights is, of course, a different tool next to other tools, like, for example, the special tribunal, how we can actually hold also Russia accountable then for human rights violations. So, in the wake of the fall of the Union, Russia joined the Council of Europe in 1996, and the European Convention was ratified in 1998. And interestingly, scholars agree that this accession, and Kristin, you've already hinted to this, that this accession actually took place, although Russia was ready for it, because of full membership criteria. As you might know, the European Convention is based on the use of a liberal constitution, no, the free expression and association, but also media freedom, democracy, and the rule of law. And here, in particular, an independent judiciary and the principle of legality. And Russia at that time did not fulfill these standards. But as Lauri Marxo writes in his 2017 book on the European Court, both the Council of Europe and Moscow thought that the Council of Europe and the European Court would provide the necessary socialization and outside legal support for carrying judicial reforms in Russia. So the question is, when did this optimism now begin to crumble? I will first of all give you an overview of these first cracks in the relationship, and then move to the second stage, which I call towards an escalation, and then to the maybe most interesting aspect, which is Russia's expulsion from the Council of Europe in March 2022. So how about the first cracks of the relationship? As Bill Bowring has rightly highlighted, already actually soon after its accession, Russia was condemned in high-level cases. I can give you two examples. For example, the case of Kuczynski versus Russia, where Russia had violated the convention by arresting the media magnate Kuczynski in order to a commercial deal, and was then condemned for having violated the convention. Another example, also very positive, was the case of Ilascu and others versus Moldova, where the court found that Russia had actually rendered support to the Transnistrian separatists, which were trying to break away from Moldova, and that the support amounted to an effective control, which is the relevant legal criterion for the court to have jurisdiction on that case. So in these two cases, you can already see that the relationship from basically the very beginning was not an easy one always. However, according to many observers, and I think this is correct as an assessment, an important turning point only more generally came about through the NATO option in Kosovo, which also affected the relationship with the European Court, because a complaint by the victims of the NATO operation was declared inadmissible by the court. And this judgment has been criticized a lot from lawyers all over the place. So it's the case, and you might have heard about it, Bankovic and others versus Belgium and others, because the court said it was lacking jurisdiction because it did not have effective control. And the problem with this, it was that in subsequent cases, for example, in a case on the Iraq War and the British involvement of the Iraq War, the court was actually not sticking to this principle and was applying different principles. So the double standard was there from the very beginning. And proceeding to the second stage already, what led then the relationship to explode? One important factor, as my boss, Angelika Nussberger, has recently put it, is a clash about values that where also the European Court has changed its position. So the European Court on the one hand and Russia on the other hand. I will give you two examples. So for example, the case of equality between women. We see that also in a lot of Western European states, the issue of equality was traditionally in a strict way. However, the court moved forward, and in the end, it really, and the case law of this court is that between men and women is to be understood in a very narrow sense. So you need a strong justification for differences between genders. And in the case Konstantin Markin versus Russia, this conflict became evident with regard to Russia. It was a case on the parental leave of male workers, which were not allowed to have actually this parental leave, unlike female soldiers. And Russia had argued that a different treatment was justified because of the role of mothers regarding maternity and the only little contribution of women to the army. But the court rejected these arguments and found that Russia had violated the constitution. So this is one point where you can see this tradition, this attempt by Russia to invoke values of tradition, of also religion, did not work out very well. And similarly, we see that with LGBTQ rights, for example, in a case Alexeyev versus Russia, a case Russia was condemned for violating the convention for not approving the organizers' request to hold LGBT. In the cases, Russia was then arguing, well, when ratifying the European Convention, Russia did actually not consent to this broad understanding of, for example, LGBTQ rights, and that there had not been a societal development in Russia, like in many Western European countries, and that traditional values like the protection of heterosexual marriage was explicitly anchored also in the Russian constitution. So it developed into a veritable cultural war. Interestingly, first of all, before I talked about the annexation, interestingly, Russia was not implementing these court decisions by enacting legislative changes, but it was still paying compensation. And this is a feature that we see a lot with Russia in relation to the court, that Russia was not implementing any legislative changes, but was still paying compensation. Malfrid and Parmentier, they have called this indulgences, like in the Middle Ages, because Russia was actually trying to keep doing its sins, but then using the Council of Europe as a political forum for its foreign policy. So the veritable turning point, the end of Crimea, of course. And also this step left its traces in the Council of Europe, because Russian parliaments were in the following suspended. They wrote voting rights in the Parliamentary Assembly, and the proceeding also about the cases about the annexation of the Crimea is still pending, are still pending before the court. We've seen the ruling of the court last year stating that the case was admissible, but we're still waiting for the merits decision. In the following, the relationships between the court and Russia further deteriorated because Russia actually goes with the idea of implementing any longer any European court decisions. And we see that with an important Russian constitutional court decision of July 2015, which made an interesting step because it authorized the Russian legislature, to create a legal mechanism allowing it to rule on the constitutionality of any judgment of the European Court, and declare it impossible to implement those judgments because they were held inconsistent with the Russian constitution, because the Russian constitution contains the principle that international treaties usually supersede the Russian constitution. However, this principle was reversed by that judgment, and logically, the Russian law actually also took this step and enabled. So a law was passed which enabled the Russian Constitutional Court to rule on whether it was possible to implement a judgment of the European Court. And this principle was then in the following applied in 2 cases which have become quite famous, at least in the lawyers' world. I don't know so much about whether historians and political scientists among you have heard about it, but at least the case prisoners vote has become very famous because it was the first case of application of this really non-implementation of European Court judgments, which of course are supposed to be implemented. So there's a rule in the European Convention explicitly stating that judgments need to be implemented. So because of the time constraints, I will straight away now pass on to the Russian expulsion from the Council of Europe, because it has some interesting also legal consequences. First of all, to give you once again and to remind you a little bit of the chronology of. So after the full-scale escalation of the war of aggression of February 24, that also my preceding speakers have referred to, the Committee of Ministers suspended the rights of Russia within the Council of Europe. And it didn't take very long, so only a few weeks later, on 15th, the Assembly of the Council of Europe called for the Committee of Ministers to request Russia's withdrawal from the Council of Europe, an unprecedented step so far. And in fact, that same day, so 15th of March, Russia withdrew from the Council of Europe and announced also its intention to leave the European Union. And only one day after, the Committee of Ministers then issued a resolution, declaring Russia to be a member of the Council of Europe as of from 16th of March. So with immediate effect, the Committee of Ministers in that resolution really expelled Russia from the Council of Europe. And then the question was, of course, what about the European Convention? Is it automatic also that apply anymore, or does it have different consequences? And here, the European Court of Human Rights, and I've recently talked to the president of the court, and he said that they were even spending nights in the library because the question wasn't so clear. As I said, it was an unprecedented step, so it never happened before. The European Court, a resolution saying that Russia would cease to be a member of the court on 16th of September 2022 only. So the idea being that Russia stayed in the European Convention for another 6 months. So you might be asking, why is this? Actually, why isn't it automatic that you as when you lose the membership of the Council of Europe, you also lose the membership of the European Convention? So the legal problems attached to this are, I would say, threefold. There are, of course, more legal problems, but I will pick out just these three, so that you have an impression of what lawyers in that context discuss. So first of all, what date actually did Russia depart from the European Convention, and was the European Court correct in fixing the date to the 16th of September? Related to this, a first problem arises because the question arises whether the Council of Europe could actually expel Russia with immediate effect from the Council of Europe. This is doubtful because the statute of the Council of Europe provides two rules: one rule for the withdrawal and one rule for the expulsion. So withdrawal is the withdrawal where the initiative is taken by the very state itself. And the problem with the expulsion is that it requires that the member does not comply with a request to withdraw. However, Russia, as I said, had actually communicated that it was about to withdraw. So I think the rule about the expulsion would not have even been applicable. And this would have meant legally that Russia would have stayed until the very end of that financial year within the Council of Europe, which would have meant December 22. The second problem related to this is a question when the European Convention ceases to apply. And here you see the provision, Article 58 of the Convention, the court applied. And this is where I said the legal question wasn't so clear, because the court in the end said, well, we apply our paragraph 3 that you see here: any high contracting party which shall cease to be a member of the Council of Europe shall cease to be a party to this convention. However, the court then took the delays that were only in paragraph 1, namely the delay after 6 months notice only, and read it into paragraph 3 of that notion. And this legal operation is very controversial among lawyers, because traditionally this provision has been understood as only referring to paragraph 2 and not also to paragraph 1. So this is one problem. And in that case, the date when Russia would have left the convention would have been very different. Just to make apparent why this is important, because we could use these 6 months where Russia still remained party of the European Convention to at least treat some cases that were still coming into the court before that, and especially the cases related to the war. So second a legal problem connected to the expulsion from the Council of Europe was the lack of collaboration of Russia with the court and the Committee of Ministers, and the absence of a Russian judge, because the Russian judge was withdrawn by Russia, so there's no Russian judge anymore. And the problem with this is that usually it is the rule that that a case against the state needs to have judged by that state in this proceeding. So the court just only recently issued 2 judgments in January, so just a couple of weeks ago, and it circumvented this problem quite, I think, elegantly, and said that, well, a lack of collaboration with the court, so the lack, for example, of not giving any observations, any written, any pose any obstacle to the proceeding, and then also the absence of judges is not a problem. And the court here applied by analogy a certain rule of the rules of the court. I cannot enter into the details here, but I think this is quite convincing, and it allows the court to still proceed with the cases against Russia, although Russia has already left the European Convention and there is no Russian judge any longer. So briefly to summarize, and to conclude, in the last years, there have been many debates about whether Europe was actually better off with Russia being inside or outside the Council of Europe. Why was it so debated? Well, because, of course, it had many positive effects of having Russia inside. The European Convention, in many cases, represents last resort for individuals. And the Convention was an important source of support for Russian human rights defenders. And then also, in fact, which should not be underestimated, because it led to a generation of Russian lawyers who knew about the convention and who knew about international law. So it had a lot of positive effects as well. However, the struggle has now been decided, at least for the coming years. And just very briefly, on the reasons for this estrangement, the deeper reasons for the estrangement between Russia and the Council of Europe, I think they are multiple and cannot be explained by one phenomenon. So I share the view of Angelika Nussberger that the relevant parties back in 1996 tried to match 2 things that were actually not meant to match well and go along very well with each other. And I think she's also right in my view to critically assess the fact that also the West shares a certain burden, because after the fall of the Soviet Union, the West was also exporting its values and its legal system and its constitutions to Russia, and this was done not necessarily altruistically, but also to gain influence in this zone. At the same time, I think the question is, what should the European Court have done differently? Should it have really sacrificed the principles like non-discrimination, like equality between men and women? I don't think so. And I think even if it had done so, I don't think it would have the conflict from escalating. Rather, I think it seems that the course of events, as always, has mainly been influenced by personalities and decisions of individuals, be it the president of the Constitutional Court in Russia or be it the Russian President Putin. So hence, it remains to be seen whether, when, and how Russia, after the end of the war, will be reintegrated into the Council of Europe system, including the European Convention, and how the mistakes of the past can possibly be prevented. Thank you very much.
Paula, thank you so much. I hope you can also hear us here. So it is both-sided communication. Can you? Okay. So thank you so much again for presenting this quite complicated sequence of steps how Russia departed from the convention to the, I guess, mostly non-legal audience. But I still believe and hope that we will be able to accept questions from the audience as long as we have our speakers connecting remotely. So do we have any questions? So the first one comes directly from the panel.
Hello, do we count as audience too? Yes.
Yeah.
I was just,
everybody except for the speaker is the audience.
This was a very good explanation of legal deglobalization. I mean, you know, we're deglobalizing legally in ways we thought we would never do. In the 90s, we were super optimistic. We were churning out, you know, laws and agreements and courts like nothing. I would just wanted to hear your sort of thoughts on where this is going, because the West is going to end up being quite alone in the human rights framework if we go down this path. And how is this going to shape the Ukraine-Russian conflict?
So if I'm sorry, I think my internet connection is not the best one. I hope I understood you correctly. So you're asking where this is going and where we end up, right? So I see that my connection again is not. So I think to be honest, I'm quite pessimistic for the moment. Because I don't see any hints, any indication we can overcome this huge gap, which is not only related to as I said, instant or concrete size, small differences, but it's more or less a culture problem, and it depends on individuals. So I think the most probably. Yeah, the step that I still maybe some hope could be that there might be actually an end of the war, which in the end, of course, would need to be a defeat of Russia, and would need to be that President Putin is not any longer any president, and that there might be a person who is willing to also accept some of the principles that have been shaping the Council of Europe. So. I think for the moment I'm not very optimistic, but we should of course not close the door either. It's as we see with in the whole debate on democracy of war. It's impossible to close the door, because it might be our last resort to actually get rid of this problem in general.
Do we have? I was asked by the organizers. We should continue now the discussion as long as we have still a connection, because it might be terminated soon. Any questions more from the audience? Yes, please.
How did the civil society in Russia reacted to this expulsion of Russia, the human rights movement especially?
I'm to be honest, I know this only from nurses, but because I have myself not talked to civil society organizations and NGOs so far, but what I've heard from them, that they are largely disappointed, of course, because for them, because they had always been fighting for Russia being in the Council of Europe, because they saw of Europe one of their allies. It was one of the last courts which was actually on their side and actually helping them, and also being on the horizon as something that is always there. Although the judgments were for a very long time not implemented, and like also the judgments at the moment that we see that the court is taking are mainly symbolic, because they're not having any actual impact, because they're permanently any longer. So I know that at least some have expressed disappointment, but at the same time understanding, because it was what could have the council have done differently? I mean, if you put yourself in the same position, having Russia now within the Council of Europe would not have been an option in an ongoing war of aggression, in my view. So it was, I think, the only choice that the council had. But it was a tragic one, because we lose this possibility to talk to Russia through the channel of organizations and multilateralism. And as you say, Kristin, it's a history of deglobalization in that aspect. Yes.
Thank you. Do we have more questions from the audience? Yes, please.
Hello, Edgar Singh. I wanted to ask very shortly, is there any possibility, or what possibilities could you see when we are speaking about restoration of justice as a main target for legal prosecutions, to bind together cooperation of post-Putin Russian leadership with reintegration in these international legal structures, for example, binding it together with the release of sanctions? Because when we are speaking about the end of the war, there are two issues which haven't been discussed yet in this conference. One is the release of sanctions, and on what circumstances relations between Europe and Russia could be re-established, and the question of reparations or restoration of Ukraine. So the question is, could the release of sanctions be binded together with this further persecutions of criminals and the question of post-war peace settlement? Maybe without Putin, but with the post-Putin era.
I'm not certain if this question really relates to the last talk by Paula that we just heard. I don't know, Paula, if you want to comment on that. Because I think
it's rather a question for Kristin and Aarif, no?
Aarif or Kristin, do you want to comment on this?
I think the danger
I'm of course happy to state my view, but I think you're much more an expert on that, because you've presented on that.
I think the danger is that Russia isn't going to care enough about the carrot. Their interest is elsewhere. They partner with China. Europe ends up as a little island and zone, and Russia sort of moves on in a different direction along with the rest of the world. You know, most of the world actually did enjoy the World Cup in soccer, except for some countries in Europe who decided to boycott. We're so misaligned with everywhere else at the moment, which is also a very significant concern, I think.
Thank you. I would also like to take the opportunity and ask you one question, namely, and this one picks up on what Kristin asked you before. Any constitutional court, and the European Court of Human Rights is a type of constitutional court for Europe, has a potential for a centralization, unless it uses this margin of appreciation. Don't you see that it might increasingly come at cost of legitimacy throughout Europe? And a second question that is linked to the former, particularly when you discuss Russia and Russia's departure, and this coincidence of this same-sex marriage case doesn't make it easier for the Russian autocrats to explain before broader public that, well, we actually withdraw because this case law that they produce is not in line with our conservative values. Doesn't make it easier to offer this explanation to the people of Russia by their leaders?
I only understood bits of the first question, so I will just answer to the second. I will concentrate on the second. So I think it does make it easier. That's the whole point. So and this is exactly the criticism against the court, that the court used the principles, that it went too far with Western style principles such as LGBTQ rights, and in doing so it lost not only the Russian leaders, but it also lost legitimacy in society of a lot of countries which do not share the views of the court. And at the same time, I'm asking myself, like, what would be the alternative? Do we want a court making this distinction? Margin of appreciation. Of course, the court is using the margin of appreciation. It is also using it with regard to the same-sex marriage, for example. And it's not demanding that every state produces a same-sex marriage, but it is at least demanding a minimum standard of legal protection for same-sex couples. And if you think about the consequence, it's very hard to make this reproach to the court to say, well, you've gone too far in your principles. You're a Western style court. Yes, it might be true, but what would be the difference? Like, what would be the outcome if it weren't otherwise? If it were otherwise?
Paula, thank you so much. Your talk was about this particular story of Russia and the European Council and the court. But you are expert on memory law, so I hope you will stay with us as we move forward to the next presentation that will be precisely devoted to instrumentalizing memory laws in memory wars under example of Russia. And this will be a talk delivered by our next speaker, so please let me introduce Dr. Vera Dubina. She, unlike former speakers, is not a lawyer, she's a historian. Currently affiliated with Forschungsstelle Osteuropa, Bremen, where she works on research project Public History in Russia as a part of her Alexander von Humboldt Alumni Scholarship. Her permanent position is with Friedrich Ebert Stiftung, Foreign Affairs in Moscow, where she is in charge of history and academic exchange. She has also been affiliated with the Moscow School of Social and Economic Science, where she teaches public history. Her former interests and engagements involve public administration, anthropology, ethnology, and her professional records features a number of appointments with several educational and research institutions in Russia. Quite a broad scope of interest. So I think, given this professional background, I think it makes you, again, a perfect speaker to share with us your insights on how memory laws in Russia develop or maybe are instrumentalized for the purpose of memory wars. Thank you. The floor is yours.
Thank you very much. Sorry for trying your patience. Yeah, so actually our panel must be shown at the end, but I tried to be short. I'm a historian. Thank you for your presentation. So I am speaking about law from the point of view from historian. It must be quite different comparing to previous speakers. I borrowed actually the title of my and part of my title from the book, famous book of Nikolai Kopasov. He's also actually historian. Memory Laws, Memory Wars: The Politics of the Past in Europe and Russia, published 2018. And his definition functioned. And his definition, the memory laws, also actually I did it for historians mostly, and not for lawyers. That's pressed in France in 2000 to refer the legislation that penalize Holocaust negotiation or recognize certain events as crimes against humanity while not prohibiting their denial. So actually this notion can be used very broad, in broad sense, encompassing all laws that regulate collective representation of the past in the narrow sense of prohibition of Holocaust denial or other similar legislation. I use it in a broader sense, so for historians it's more important that this collective representation of the past. This is rather than a single type of legislation, the term in fact covers a complex of different related phenomena. In this broad case, it includes laws that define state symbols, create museums or grant amnesties or benefits to participants in certain historical events. The post-war, I mean war, World War II. So now we need to say this. In the post-war decades, historians developed an increased focus on the oppressed and eventually moved from objective social history to the interest in multiple subjectivities. This paved the way for a democratization in the form of memory boom that stripped historians of this monopoly on legitimate history writing. That very sad thing for historians, of course. The past has become a source of heritage defined by its role in the present. And so most of the historians not really happy with this and not really doing with this and not happy, of course. But since the 90s, 30 European countries have laws criminalizing statements about the past on their books. However, initially convinced in the means of maintaining peace, these laws have instead become one of the preferred instruments of the memory wars within and between many European countries. So in case of Ukraine, Georgy Kasyanov, that's a famous Ukrainian historian that writing about Holodomor, he named it memory crash. So memory laws was an important instrument in the memory between Russia and Ukraine. And this memory crash, it's what's happened on the basis of this memory laws. Now it's unfortunately a real war. So all fans of memory laws support need to be aware of its potential dangers. Oops, sorry. Here. Laws that, sorry, here's a mistake, I couldn't correct it. It's in the middle of this abschnitt. Laws that regulate collective representation of the past are not a new phenomenon, but laws that criminalize certain statements about the past are. And even in USSR, with its formidable system of censorship, had no memory laws in the narrow sense. The emergence of memory laws in the strict sense shows that in the age of memory, the past became even more important for cultural identity and political legitimation than it was in the age of history-based political ideologies. And what happens now in Russia? We can define as crimes against history. It's about, actually since 2014, it's already could be qualified crimes against history. It's Anton Debate's term as a crimes against history. His book also 2018, also the book of Nikolai Kopasov. During the President Putin first term, 2004, the presidential administration denied any need of state ideology. They never do something with past or even some kind of prohibition of laws. But the aggressive offense of historical politics became visible to all after Medvedev presidency, so after 2012, a little bit earlier. And the first known article, 354.1 of the Criminal Code, Russian Criminal Code, which criminalizes the rehabilitation of Nazism. The law was introduced in the State Duma during Medvedev, the Russian parliament, during Medvedev presidency in 2009. The bill provoked widespread disapproval, including the Cabinet of Ministers, silence about historians. They also protest against it. It was not discussed for several years until it was revised and quickly passed in May 2014 against the backdrop of the Ukrainian crisis. In 2020, the official historical narrative was established in the Constitution of the Russian Federation. So it's a very sad thing for historians that the Russian state is so obsessed with history, but that's the case. This article 354.1 dissemination of knowingly false information of activities of the USSR during the Second World War. The title of the law is misleading, for it actually penalizes a much broader range of expressions, not only about Nazi crimes, but also about the role of the Soviet Union in the Second World War and about Russian military history in general. Rather than protect the dignity of the individual victims of state crimes, their purpose is rather to enforce an officially sanctioned way of relating to the past, as a means of strengthening national identity. These clauses permit the state to prosecute those who share government disapproval, although read false views on Soviet Union's politics during the Second World War, or who express something disapproval opinions about Russian military history at all, or military operation now. Between 2015 and 2019, enforcement of Article 354.1 of Criminal Code has resulted in 25 convictions, and only one acquittal, not including an unknown number of criminal cases that did not reach the trial. And ironically, this man who acquitted, ironically, the only acquittal under this article was a Holocaust denial case, as that's irony. Roman Yushkov, a resident of Perm, a city in Siberia, wrote on social media that the so-called Holocaust was a shameless swindle intended for non-Jews, Germans, Russian, and everyone else. Quotation end. He also questioned the Holocaust deaths, saying their estimate of 6 million Jews was a great fraud. So instead, the majority of the proceeding under Article 354.1, to the extent they are publicity available, concern those who speak about the Soviet Union international crimes committed between 1939 and 1945, question the official narrative of the Soviet Union role in the Second World War, or invoked history on their critique of the Soviet regime. And it's only one who this man in Perm, he protested against the Jewish memorial that must be built in Perm. So he just put his ideas about Holocaust on internet, and it was at first he was sent to the court and then free. This article, particularly striking in the current only slight reference to the Great Patriotic War, in contrast to the previous phase of the war in the Donbass, which has been going on since 2014. So this Russian slogan we can repeat that appeared after the annexation of Crimea actually goes back to the inscriptions left by Soviet soldiers on the walls of Reichstag. But now, this Berlin, for example, and this one, this is from the inscriptions of the Reichstag. But what we see now, that's what we see now after the beginning of this war in Ukraine. So this is a military parade. This is photo from military parade in St. Petersburg, in May 2022. So what's a striking resilience, yeah? Who is you seeing here? This is a military police regiment, but it looks like the Nazi troops, and of course that's not hiding from anyone. I don't know if it was a kind of silent protest from designers of this uniform, that they're doing Russian police looking like Nazis, but yeah. So it's nothing that now is nothing going to this Second World War narrative. Yeah, what's happened now in memory discourse. As radical as it is, the Russian case points to broader tendencies in the evolution of the legislation of memory, so which is now being widely used in promoting nationalistic goals. So in the Russian constitution, for example, official historical narrative was incorporated. It's a new, also other new articles that you can see about fake news. There's most of the people now convicted on this article about fake news. So we now in Russian courts, they still need to publish in internet, but they try to violate this. I don't know, they're saying that doesn't working or something like that, but we collect around 5,000 cases that the people convicted on this article in administrative court, and 2,000 cases in criminal court. The longest as a case that's in 9 years in prison for this on this fake laws. The person who put on internet the atrocities about the butcher, he was convicted for 9 years. So it's of course a radical case how it used now, but I mean that must be aware that also the whole European also society. So I think that's just at the end to show you something nice. That's how the people protest against the war. The artists, that's for endless 20 years we have waited with hope for the belly. So belly was symbol of the death of the Soviet leaders. So when I was a child, I've seen belly. That's after the death of Brezhnev, every 2 years. And the whole week was just a belly on the television and nothing else. And also in 90s, it also when in 1991 putsch, they also see 3 days just a belly on the television. And on your left side, you see no war. That's Russian "Нет войне." It's 3 and 5 letters. So they just in ballerinas. So that people. This is from St. Petersburg in April of 2022. So that the people could understand that there's no war, because it's prohibited now to say no war on this fake news laws. So on this, so that they have a beginning in memory laws actually. So thank you for your attention, and your patience.
Thank you so much for this presentation, for sharing your experiences with us. We were now supposed to listen to a 5th and last presentation, but then the reality comes, and instead of this presentation, I would just, before we move on to discussion, I will read you. No, there will be, but before that, reality tells us something, and instead of having our 2 speakers connecting at least remotely from Kiev, I can just read you an excerpt from an email I received from Mikola, one of our speakers. We would like to inform you and apologize to you and other participants in the event that we will not be able to speak at the conference due to the lack of light, which has been turned off as a result of a military terror by the Russian Federation. But we hope that this will not happen. But apparently it happened, so for a couple of hours now we don't have connection with Mikola and Tatiana, so I hope they are safe and all right, but this is the reality of the war that affects also this panel, so our thoughts are with our colleagues who are now in Kiev, so we will not be able to have them during this conference. Maybe tomorrow, I don't know, it's all up to the organizers. So this is the message from them that I just pass over to you to revigorate our empathy so that we never get used to what is happening, because it's been a year and people tend to get used to things, and this is something we should never get used to this atrocities happening in Ukraine. Now we would like to, because we started later, and we also will want to use this little time left for a final round of discussion. So if there are any questions, specifically to Vera, our last speaker, but also to Kristin, our former speaker, then you are free to ask, and please, Kristin, go ahead with your first question.
I would just like to say that we drafted an answer to Deborah's question before he left, but we can take that. It's here in writing. I have a question for you, because I just learned so much from your wonderful presentation. And so last year I was giving a paper in Austria about the Norwegian terrorist. I was going to use footage where he's doing the Sieg Heil, and then I was told you can't use this footage online in Austria. But then, you know, what is Nazism after this war? You know, there are Ukrainian and Russian Nazis, and then each side accused the other one of being nothing but. So the whole concept is changing, like you said. It's sort of the past is moving. I mean, how do we sort of maintain some sort of meaningful understanding of what this actually is when it's being so kind of repoliticized?
Oh, it's already on. If I correctly understand, you wouldn't how we work with Nazism term, yeah. So now, how we understand? Of course, for historians, there's no problem how to understand it, but nobody here is historians. That's a problem. That's a problem in Russia, and also we have a case that in 2015 that one historian put in his report that there's 28 Panfilovцы, it's mythos of the Second World War, that they killed 40 tanks actually and stopped 40 tanks and actually all killed. It's only mythos, yeah, that they make from the newspaper journalist, and he put it just a document from archive about it, and he lost his position, yeah, after that, yeah, because the Minister of Culture, that's Medinsky, they're still there. It's in other position, but still very powerful. Just mythos is more important, yeah, that what historical thinking. And now, if you can convict it for 20 years on this fake news, so if you're a historian saying something that going astray from the meaning of the I don't know, president of whom actually, so you could be convicted, and it's on purpose not specified. Yeah, where you can, as you don't know when you can be convicted for what. Yeah, actually, what is false, what not. They never specified it. That's like a repression. So you must censorship yourself. So you will be afraid of everything. Yeah. So you never actually take part in this and go to your private life and try to be safe. Yeah. So that's the idea there. But I mean that for this memory laws was used, and for all these 10 years, almost 10 years, after 2014, they actually never thought that they will come to the war after that, yeah. So it's how dangerous it could be. Now we can see this, yeah. But of course, it's a constellation of dictatorship and no real justice and all the same. From other cases that the judge just never shows in the law, and for example, there's a very famous Serebrennikov case that he was convicted for robbery, that they take the money from the state and never did his theaters places. But I've been there, yeah. We go into the court and saying we've been there, yeah. We've saw this. That doesn't matter. There's a judge. He will be convicted. So in this case, for Russia, laws not playing the same part. That because when I'm hearing you, it was a little bit strange for me, but not because I'm not lawyer, because in Russia nobody pays attention what's inside this law, because it's very important how it will be then after that. If it will be how to say it in English? I mean, as in special term, yeah. If they will be persecuted or not, yeah, that is important thing. But I mean, for historians, no problem how define Nazism, yeah. But politically, it's other thing.
Thank you. Do we have more questions from the audience? Yes, please.
I have questions to both speakers. Thank you for your fascinating presentations. So my first question to Dr. Dubina. the first question is about uses of these memory laws. So as far as I know, these memory laws you told us about, they are used only against political activists in Russia. I don't know cases when these memory laws are used in case of professional historians. I mean university-based historians, historians employed in Russian Academy of Sciences, or maybe you know such cases. So I would like to have your comment. And my second question is about new institutions of historical research established in Moscow 10 years ago, this Russian Historical Society and Russian Society for Military History. So in the context of these recent events, what we have with Russian military invasion into Ukraine, one can expect that the Society of Military History would be more active in its conferences, public events, exhibitions, and so on. Instead, in my view, Russian Historical Society is leading in this, to say, quasi-historical performance, or providing Russian military invasion with some historical context. So how can you explain it, why Russian Historical Society is much more active and visible than Russian Society for Military History? And my question to Professor Sandvik about international law and war of aggression. So if we will put it in a more broad context, so we will see that for many decades Kashmir is occupied by Pakistan, and northern part of Cyprus for 50 years is occupied by Turkish Republic, and many other examples. So the only positive case which I can recollect is a small island of Eastern Timor, which was occupied by Indonesia in 1974, and recently, like 10 years ago, finally Eastern Timor got independence. So I'm not an expert in international law, so maybe you know if Eastern Timor sued case against Indonesia, or if they got some compensation, or whatever you know in this context. Thank you.
So I will be the first. There are some historians who are already convicted for this criminal code law 345.1. But at first, the first person was Justin Mechanica from Siberia, from Novosibirsk, I think. It was who he put in internet. Actually reposted in internet an article about the Molotov-Ribbentrop Pact, also the Stalin-Hitler Pact, and he was convicted. It was administrative court at that time, and historian, military historian got 4 years for this. It was in 2017. But now, actually, after the beginning of this war in Ukraine, it's mostly this fake news. It's another article. They use it still, this article about the falsification of the Nazism, but also they have extremism article and terrorism article, and this fake laws article. This, from criminal code, it is most heavy, so to say, 20 years it must be. The longest until now it's 9 years, but it could be 20, yeah? So everybody knew this.
So this fake news, it could be everything. Yeah, so it's easier that the other article about Second World War, actually. It was also used against historians, but not so bright that now. And now they just have another problem, the historians, they just lose their position at universities if they say something against the war. Yeah, so they changed an administrative court that you could lose your position if you're a teacher or a university teacher just for saying something against the war. So it's that's the problem, but not so many historians probably in a prison still. But it not only used against political activists. I told you that the first one was just normal person who just reposted an article they already published in internet. And another question was about historical society, that actually the same thing. The background is from Medinsky part. Yeah, so it's военно-историческое общество, российское историческое общество, you mean, yeah? That's actually from the same root, yeah, that the boss appealing to Medinsky, that the former cultural minister, and now he's a советник, or he also took some position now in the Russian administration. So they also visible, the военно-историческое общество. They grab this, Sandamoh, for example. They try to convince that they're not the political victims of political repressions there, but some Russians killed by a Finnish army. Yeah, so. And Memorial Society was active there, and they just go in with the cameras and make footages because they have they was scared that they just put something inside to prove that it will finish. Yeah. So the matters of these societies, and now they have a program of patriotism program for children. It's actually a military training. Yeah, and the parents doing nothing against it because they recruit from very poor regions. So this is probably the only possibility to go up. Yeah, so for these children, and they're actually really in military training, what they're doing there now. That's the Russian military society doing these things, and they have more important now, probably, like American military.
We want to give Kristin also the chance to answer, because soon we will need to leave the building because of time restrictions and security and so on. So if you could please briefly address the question that was asked.
I'll take the liberty to see this as a question now of the limits of what law can...
Besucherinnen, werte Besucher, wir möchten Sie darauf hinweisen, dass die Ausstellung um 19 Uhr schließt. Werte Besucherinnen, werte Besucher, wir schließen um 19 Uhr.
Danke.
Wir danken uns für Ihren Besuch.
Ich höre.
Auf Wiedersehen.
Auf Wiedersehen.
How you believe?
The law can only do so much, right? So it's a problem with European Court of Human Rights. It's a problem for Ukraine. It's a problem for many, many other victim populations. The law itself, institutions, they try to admit fewer cases, select cases, be strategic about what to select, but it is something we need to reflect on with respect to Ukraine. We can probably only successfully litigate very few cases and should work on expectation management. Because if people feel that the law does nothing, right, it's easy to dismiss this as hopeless. But frankly, we don't have that many other institutional pathways. So this is part of the conversation I just think that we need to have. The law can do something, but it can't do a lot.
Is your question that short that can be asked and answered during 3 minutes? Then go ahead.
No, it's
under this condition.
Thank you. It's just one question. I appreciated both speech. I would like to link it together. There is a historian. His name is Nikolai Eple, and he wrote a book, An Inconvenient Past. So his proposal is to make transitional justice in Russia, in the future Russia, democratic Russia, by create Truth, Justice and Reconciliation Commission in order to judge the crimes of the communist past in the same way as it was in, let's say, South Africa. So what do you think about the possibility to make it in the future democratic Russia what Nikolai Eple proposed? Thank you.
The Russians need to help themselves. They need to rescue themselves.
Oh.
But I don't think anyone can impose anything. I mean, any solution, any pathway, any sustainable federal was suggested here today needs to be found by the Russian people.
I'm not a politician, I'm just a historian. Yeah, that I just saw what's this little deal of this memory laws. Yeah, if you prohibited some interpretation of history, it's not a history anymore. Yeah, so it's a I don't know, ideology. You can use it very handy. Yeah, against any political activist or against actually historians themselves. So history is a scholarship. Yeah, it have other actually tools. I think that you couldn't prohibit something. Yeah, and if you have a justice, yeah, you must have a strict laws. Yeah, so otherwise, how you can justify it? Post-communist laws in Eastern Europe also like a memory laws. So I don't know. Yeah, actually, I hope for the GAG or some kind of for this military atrocities. But about history, it took a lot of time, and no commission could solve this problem, I think.
Well, the entire discussion about memory laws, we must stop here as an unfinished business. It will be continued actually by the first panel tomorrow that will come close to these issues. But since we are really out of time, I would like to express my gratitude to the speakers, the two ladies who still left with us, and to former speakers, and to the audience, and to the organizers. And we look forward to continuation tomorrow. Thank you so much.